So the ATF just admitted in a letter that AR-15s are not machine guns. So let's talk about this. But real quick before we jump into this video, if you think that the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of the channel, which is Blackout Coffee. Blackout Coffee has some of my favorite coffee and two-way supporting coffee out on the market. So if you're interested, head on over to Blackout Coffee's website, and if you use the code ARMSCHOLAR, you can get 10% off of your order. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I mentioned in the intro, the DOJ just submitted a letter to the Sixth Circuit Court of Appeals in the GOA v. Garland bump stock case. In this letter, the DOJ/ATF admits and clarifies that AR-15s are not machine guns and should not be considered as such. Now, some quick background on what happened and how this all wound up in the Sixth Circuit en banc Court of Appeals and what this all involves. For many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the tragic events in Las Vegas, the ATF, after being ordered by Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be considered to be actual machine guns. This new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or surrender them to the ATF. Now, this lawsuit was a result of GOA and plaintiffs in this case representing a class of general people who legally acquired bump stocks prior to the ATF's final rule, determining that bump stocks were a combination of parts that convert a weapon into a machine gun, and therefore ultimately determining under the ATF's new interpretation that bump stocks themselves were actually machine guns. A three-judge panel in the Sixth Circuit, in reviewing this case, found that bump stocks did not meet the definition of a machine gun and invalidated the ATF's interpretation. The ATF, of course, did not like the ruling and subsequently sought an en banc review. An en banc review is a review by a larger set of judges in the circuit courts. The en banc court in the Sixth Circuit heard oral arguments in this case in October, and during those arguments, the court requested information and clarification from the ATF on the phrase "can be readily restored to shoot" in the definition of what a machine gun is. Specifically, the court wanted clarity from the ATF if all AR-15s are considered to be machine guns under the readily restored language in the GCA. Well, in response, the DOJ submitted a response letter, and in it they clarified that an AR-15 is not a firearm that can be readily restored to fire automatically and therefore is not a machine gun. So let me read to you the letter real quick because it's only a few paragraphs and it adds some more clarity on this whole issue. The letter states, during oral arguments in this case, the court requested information about the meaning of the phrase "can be readily restored to shoot" as used in the statutory definition of a machine gun. A machine gun is any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The definition also includes parts that can be used to convert any weapon into a machine gun. The letter goes on to say, in a series of classification rulings, ATF interpreted "can be readily restored to shoot" to refer to weapons which previously could shoot automatically, but will not in their present condition. For example, they state, a machine gun that has a part known as a disconnect added to it, which prevents the weapon from firing more than one shot by a single function of the trigger, remains a machine gun because it can be readily restored to shoot automatically by the filing down of the disconnect. So here you have the ATF saying that a firearm that could fire automatically prior does not lose its classification as a machine gun simply because something like a disconnect is added. Their stance is that a temporary modification on the firearm does not remove the status of a machine gun if that part could be removed or changed, and then that firearm could then automatically be able to shoot automatically. So just a temporary condition or modification does not remove that status of a machine gun under the ATF's kind of viewpoint here. The letter goes on to say this court concluded in a prior case that a weapon made from cut up M14s also fit within this definition. Congress's use of the phrase "readily restored" precludes defendants from evading the statutory prohibition on possession of machine guns by maintaining machine guns in a temporary, modified state in which they cannot fire automatically. The ATF's classification of bump stocks as machine guns does not involve a circumstance in which a firearm can be readily restored to shoot automatically. ATF concluded that a bump stock is a machine gun because it is a part that converts a weapon into a machine gun. At oral argument, the question arose whether ATF's interpretation of machine gun to include bump stocks indicated that all AR-15s must be machine guns pursuant to the readily restored language. As noted, the classification of bump stocks turns on the fact that a bump stock is a part that converts a weapon into a machine gun, and it thus does not bear on the readily restored analysis. Now, this is something really important that I want you guys to pay attention. The very next section is really important for the whole context of this video. They go on to state, in any event, an AR-15, a semi-automatic firearm, is not a weapon that previously could shoot automatically, but will not in its present condition. A part that could transfer an AR-15 into a fully automatic weapon might fall within the definition of a machine gun. The existence of such kits, like the existence of bump stocks, does not transform an AR-15 into a machine gun. So what does this all mean? Well, you have the ATF stating that an AR-15 is not a machine gun under the statutory definition. That's just what they did in that prior section. This is obvious to all of us because we know a standard semi-automatic AR-15 will fire one shot per pull of a trigger. But here you have the ATF themselves saying, yes, an AR-15 is not a machine gun. Also, they say that even adding kits like bump stocks onto an AR-15 does not automatically transfer all AR-15s into a machine gun under the statutory definition. They say that the part itself may be determined by the ATF to be a machine gun, like auto sears or maybe bump stocks, but the AR-15 with the part may not be considered to actually be a machine gun. So I guess the assumption here is that if you remove the part, then the AR-15 goes back to the natural non-automatic state, being semi-automatic, which is different from some of those other situations they talked about where there may be something temporarily modified in a fully automatic firearm that makes it shoot semi-automatic, but if you remove that, it reverts back to automatic. So they're trying to draw that distinction there between the two different types of firearms. So it's interesting to have the ATF clarifying that AR-15s are not in fact machine guns under the statutory definition. Now, one important thing that I want to note is that the ATF has a very long track record of clarifying something to not be a machine gun and then essentially just going back on their word, reinterpreting something and then saying, well, in fact, it is a machine gun. For example, that's exactly what they did with bump stocks. Previously, they said that bump stocks were not machine guns, but now they say that they are indeed parts that convert a firearm into a machine gun, and therefore bump stocks themselves are machine guns. So you can see how prior they said, no, it's not a machine gun. Now they're saying it is. But the one good thing out of all this is that this letter does add some ammunition for later litigation if the ATF ever tries to go back on their position that they're holding right now. Hopefully that doesn't happen, but if it does, later cases can point to this letter and say that the ATF prior had said that AR-15s by definition are not in fact machine guns, that's exactly what they said in this letter. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting these videos, impacting this channel, and helped me reach 200,000 subscribers by the end of the year, which was one of my big goals, and you guys helped me crush that. So thank you guys so much for all the support. If you don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm, and that really does help. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.